Again, good morning all. 12th of May, and the witness was still under cross-examination. If I may remind you, sir, that you are still under oath.
Yes, Chair, thank you.
Yes.
Good morning, Chairperson. Good morning, Mr. Tusai.
Good morning, Mr. Salukazana.
Yes. Chairperson, I will start today by referring to the Auditor General's report, and the Chairperson and the Tribunal will recall, at least the President in the Tribunal, will recall that we referred to this when we were discussing the findings with regard to the legal panel with Ms. Matangoe. I ask that you go then to volume 16 of 1. The report itself starts at 381, but I wish to specifically
Yes.
Yes, so the report starts at 381, but I ask that we turn to 476.
I'm sorry, what volume number is that?
16 of 1.
And we go to 473.
476, Judge Mashidi. Mr. Dingiswaya, please let me know when you're there.
Yes, I'm there.
You are a member of the executive, at least insofar as legal services are concerned, correct?
That is correct.
And am I correct to assume that you will have seen this report?
No.
So you haven't read the Auditor General's report of 2017?
No, I don't remember. I don't always read the Auditor General's report.
Okay, even the ones about PRASA?
No. Yes, I'm talking about those, yes.
Okay.
Yes.
May I ask then that you turn, are you at page 476?
Yes, I am.
Yes. Chairperson, you will recall yesterday that we referred to a list attached to a letter making an inquiry about employees of PRASA who are either associated with or have partners that do business with PRASA and were flagged. And may I ask that we go to the sentence that begins just under the table with P.S. Bopomolefe, and the sentence I will start with starts with upon discussion.
Can I just get clarity? Are you referring to the Auditor General's report or?
The Auditor General's report.
And which appears at page 146 and paragraph what?
Not 146, President, it's 476.
476. Yes.
Yes. And again, you will recall that yesterday, Mr. Dingiswayo, you raised an issue of there not being a finding about your being listed as an associate of yours doing business with PRASA.
Yes.
Yes.
Sorry, yes.
Yes. And so in answer to that, I wish to refer you to this section of the Auditor General's report that makes that finding. And I will read to you the entire section, if you'll allow me. It starts, upon discussion with the acting Chief Procurement Officer, it was noted that all PRASA employees were required to complete an annual declaration of interest with exception of the supply chain management officials who are required to complete declarations twice a year. During the testing of the supply chain management, it was noted that there were a number of employees who did not complete their annual declarations. The list of employees is contained in the table below, and the further related suppliers did not declare their connections as well. I ask that we go to the line item under, so it's name of employees is the column I wish to refer you to, and 1, 2, 3, 4, 5, 6, 7. Is that your name?
Yes.
So there is a finding, do you accept, at least by the Auditor General, that you are one of the employees that had associates doing business with PROSA and did not declare that, correct?
This is a strange one, you know. Chair, because if you look at that box on 477, it has nothing. And I mean, if I just make an example with 481, there's a similar box which is populated. But the box on 477 about management comment on audit finding, management comment on internal control, there's nothing. Now,
Yes.
I'm really not sure what to make of this, and I think in my testimony yesterday, I did indicate that, Chair, that is the process that is ordinarily followed by the AG. So I accept that what you are reading here is in these pages, but I'm also pointing out, Chair, that there is something strange about this finding. I'm not certain what to make of it, but yes, that is written there in this document.
Yes.
Yeah.
It's a finding by the Auditor General. I ask then that you turn to page 477, I beg your pardon.
Page 477.
477, yes.
Okay.
Apologies. And the sentence that starts immediately under the table says, the above non-disclosures result in non-compliance and could have an impact on the awards made to these suppliers and could possibly result in irregular expenditure. So you accept that insofar as you are listed as one of the associates or at least employees who do business with PROSA, you pose that risk of irregular expenditure, at least according to this report.
According to what you are reading
Yes.
here, yes.
I'm reading the Auditor General's report.
Yes.
Yes.
I'm saying according to what you are reading here, Chair. You'll recall, Chair, the letter that was sent to Peter Malele says to him, look at these people, look at these suppliers, check whether there was anything. My sense is that because this management response is not completed, that response was not made. Now, it begs the question, on what basis is the finding made if management has not responded to it?
Yes. And let's go then to, still at 477, to recommendations. And I ask that we refer to the third bullet point. Management needs to implement the necessary disciplinary processes against employees who fail to comply with the requirements being disclosure. Have the management instituted or initiated, or did they, now that you're no longer there, institute or initiate disciplinary processes?
No, not about
Against you.
Pilato.
Okay.
I've never. I mean, I think there's a lady that I referred to who was dealing with the CIA companies. Her name appears as the second name there. It's GS Khorata Mokotedi. And I think this came up, and when we were asked, it was ridiculous the kind of connection that the AG had made. Because it was someone that they were together in some burial society, and then the Auditor General made a connection with her because of that, and that burial society was not even functioning at the time. So it was, I think this was the issue that led to there being no response on this particular finding. And I mean, you can see at the end, they say this will be followed up in the next audit cycle. Nothing came out of this. There was no disciplinary thing. I don't even know what follow-up by the AG happened and if it happened at all.
Sorry, you lost me there, Mr. Tingiswai. Who's linked to the funeral parlor or funeral parlor?
Mokotedi.
Chairperson or President, is evidence about Ms. Mukotedi or Mr. Mukotedi relevant? Can I pursue that?
Well, question is this evidence relevant? But you, well, put a question or two and see where we're going with this.
Yes, through your guidance. I submit to you or put to you that that is irrelevant because we're dealing with a finding that is made directed about your associates doing business with PRASA. So what you say about Ms. Mukotedi is irrelevant. Do you have a comment about that?
Yeah, I think you're right. I agree fully with you.
Yes.
This entire thing, even about my name being appearing here, is completely irrelevant. But I mean, these are the questions you're asking. You brought these documents. You brought this finding.
Yes.
And I'm answering questions on that.
Yes.
But in my view, I agree with you completely. All of it is completely irrelevant.
Well, your agreement with me stretches what I'm saying. I'm saying evidence about Ms. Mukotedi is relevant. The fact that you were doing business with PRASA is relevant because it speaks to your interest in what the board pursued, is what I put to you. Any comment on that?
I don't think there's any evidence that he was dealing business with PRASA. He's just saying that that is just not so. Let's put it to him directly. Were you in any business relationship with PRASA, you yourself?
No, Chair.
Chairperson.
The question was put to me yesterday, and I said no. I've never done businesses with PRASA. This company that is listed here, I don't know it.
Yes.
The person who's said to be a director there, I don't know these things. So, but I think the other thing is that the tribunal is looking at the conduct of Judge Makhubele. And maybe I'm a criminal, I'm a rapist, but I'm giving evidence on the conduct. And the fact that maybe I'm a criminal is irrelevant, I think, to this tribunal.
Now, we just want to know, and I think it all goes to the fact, is that were you or any of your associates that you know of, let me put it as broadly as that, doing business with PRASA? Yes or no?
No.
Thank you.
President, with respect, you've rephrased my question. Mine was one that was referring to the AGSA's findings and that the AGSA has made that finding. What the witness now says does not change what the AGSA has found. So insofar as answering your question, we welcome that. But my question was a different one, and I'd like the record to reflect that.
Well, we've got the AG's findings, and whatever the AG's findings, you can argue how it is relevant to this inquiry when we eventually get to that particular point. But he says that the findings, if it is to be read that he was doing business with the PRASA, is wrong.
Yes, again, we follow the AGSA, and whatever the president and the witness say, we will interpret in the light of this. May I ask that then we go to the transcript of the inquiry? That's still at 6:1. 16, I beg your pardon. And the pages from which I wish to start is page 260.
260.
Yes.
Yes, I'm at 260.
And may I ask that you start with Mr. Advocate F.W. Bortes, where he starts with shortly after your employment. Can you see that?
Yes.
And I ask that the tribunal bears with me a recitation of the transcript, at least the parts we consider relevant, is necessary, again, to put into its proper context our submissions later, either to the tribunal or the JSC. It starts shortly after your employment, and more specifically on 31st of May 2011, an agreement was entered into and concluded between PRASA, your employer, and the company in liquidation. Do you accept that the company to which Mr. Bortes refers to here is CIR DB Consulting?
I think it's called CIR Consulting Engineers.
Okay, we'll correct that. If you're correct, I accept your correction. Thank you. I want to present you with a copy of that document, and I want to ask you whether or not you have seen this document before. You will see on page 2, Mr. Baltic, the scope. Page 2, the scope, paragraph 1, the subject matter of this contract is the performance of services of technical assistance for the signaling, supervision of the National Re-Signaling Project, stage 1, phases 1 to 5, that falls within the indistinct at PRASA. Is that correct? Mr. Baltic, yes. Do you accept that Mr. Baltic is confirming that a contract had been concluded on 31 May 2011 between PRASA and CIA, the company you referred to?
Yes.
And if you turn to page 4 of that document, you will note right in the middle of that page, this is Mr. Bortes, that it was signed on behalf of consultant, that is the company by Mr. Makenza, I think it's supposed to be Mabunda, but it reads Babunda, who is the chief executive officer, and Mr. Lucky Montana, he was at the stage, the group chief executive officer of PRASA, signed the document on behalf of PRASA. Yes, sir, it was a question, or, and then Mr. Bortes says, yes, it was a question. Do you accept that the person who signed on behalf of PRASA, according to Mr. Baltic, was Mr. Lucky Montana, was the CEO at the time?
Yes, that's what is written right there, sir.
Thank you. And then to move on to Mr. Bortes again. So you confirm that this agreement was entered into and concluded, and if I understand you correctly, you are familiar with what is contained herein. Yes, says Mr. Baltic. And then Mr. Bortes, referring to the commissioner, seeks leave to introduce the document. May I ask that we go to the last reference to Mr. Baltic, still on page 260. I mean, Mr. Bortes, beg pardon. Mr. Bortes says, Mr. Baltic, will you confirm that the value of the agreement, that's ineligible, at least on my document, with you, if you turn to page 2, it seems to be 54.5 million. That is according to the item on page 2. Do you accept that here they're referring to the value of the works, at least that were supposed to be performed under the agreement we have just referred to?
Yeah, it seems so, I mean, if you
Yes.
follow the logic.
Thank you. Then, Mr. Bortes, in general, can you explain to the Commissioner what was the purpose of entering into this agreement? Mr. Baltic, yes, Mr. Commissioner, was having a contract for signaling works with the contractor called Siemens, and PRASA have decided to appoint a technical advisor and supervision in accordance with FDIC, which is FIDIC rules. And then there's an engagement about how to spell that. May I ask, or at least what it means, may I ask that you then go to the second last reference to Mr. Advocate F.W. Bortes, which starts with the FIDIC reference. And it reads, FIDIC, can the Commissioner accept, Mr. Baltic, that CIA, and that is the company in liquidation, I am just going to refer to it as CIA, was then duly appointed pursuant to the conclusion of this agreement to do or to conduct or to execute whatever is provided for in this agreement? Mr. Baltic says, correct. Mr. Bortes, again, ineligible on my part, so I'll start on personally. You were personally involved and had personal knowledge of the manner in which this contract or this agreement was implemented and executed. Mr. Baltic, that is correct. Do you accept that Mr. Baltic was responsible for the implementation of this agreement?
No, he says he was...
To your knowledge, because I remember you said he had signed one of the agreements, to your knowledge, with this one, do you accept that he was responsible for the implementation and execution of this contract?
Yes, I think so. I think the projects, the re-signaling projects and the new rolling stock projects were under, no, sorry, not new rolling stock. Signaling was definitely under Baltic, correct.
Thank you. Then next, Mr. Bortes, will it then also be correct that you personally have knowledge of the scope, the ambit, and the quantification of the works? Please define for me ambit, says Mr. Baltic, and then Mr. Bortes stutters. Then Mr. Baltic says the ambient, or Mr. Bortes, Now, the ambit being the extent exactly what had to be done insofar as this agreement was concerned, was the scope, asked Mr. Baltic. Mr. Bortes, yes. I'll just skip the stuttering and back and forth and go to Mr. Bortes. The ambit and quantification, the quantification, Mr. Baltic responds, yes, sir. In other words, rands and cents, yeah, I do understand, says Mr. Baltic. The answer is yes. Yes, good. Will it be correct? And please tell me if my statement is not correct. Mr. Baltic says, if you lie to me, I will do that. Mr. Bortes asks, will it be correct for the Commissioner to accept that whatever responsibility or liability pursuing to this agreement was that CII has complied with it? Can you please repeat the question? Asked Mr. Baltic. Mr. Bortes says, can the Commissioner accept on your evidence that CII has complied with all its obligations referred to and contained in this agreement? Mr. Baltic says, CII did comply with the conditions of this agreement, according to my knowledge. Do you accept that this was Mr. Baltic's evidence at the inquiry on the 27th of August 2017?
Yes, that's what
That is evidence before this commission of inquiry was that CII did perform under the May 2011 contract.
it's written here, it's written in his report.
Thank you. Then Mr. Baltic says, let us just re-inference your answer. I'm going to ask you this question, Mr. Baltic. From your perspective, from your personal knowledge, do you have any reason or basis to believe that CII has not complied? Mr. Baltic, I do not. Mr. Bortes, you do not, questioning that. Sorry if I got the intonation wrong. Very well. Now, let us cut through all the peripheral issues, and I'm going to hand the document to you. I have made enough copies I can give to Mr. Tatsoana. He refers to that. I ask that we start at the sentence that says, it is a statement, and this statement refers to what is contained in the agreement that we have just dealt with. And Mr. Baltic, you will see that there are provision has been made in this statement for a date of invoices. Then there are invoice numbers, the amount which appears on the invoice number. Mr. Baltic says, yeah. Mr. Bortes, there is a VAT component. Mr. Baltic, yeah. Mr. Bortes at page 263. And then there is an amount including VAT. Mr. Baltic, yes or yeah. And then there is a provision for certain months. And then in the balance column, there is a reference or there is that contains an indication when certain amounts were paid and so forth. I want to give you a minute to familiarize yourself with the statement. Mr. Baltic, yeah. And whilst you do that, do you confirm that the invoices that since 6 August 2014 as provided for in the statement, starting off with K4001 up to K3046 were issued by CII to PRASA? Mr. Baltic, it looks correct, yes. Mr. Bortes, and it seems that when one has regard to the month insofar as it starts off with mobilization, it says that all these invoices were paid until the third entry from the foot of the page, there where it is indicated October 2016. Do you see that? What about the one November? Yeah, well, let's start with October. Let me stop there. Do you accept that Mr. Baltic is testifying here that at least up to 2016, PRASA was paying for the services CII was performing?
Yes. Chairman, I'm not sure. Am I supposed to confirm that his reading is correct?
Well, again, not being as influent as you are, my reading may be faulty here and there. If you could just confirm what the evidence I referred to is.
No, your
that
reading
it's
is
recorded.
fine.
Yes.
It's very good.
Thank you.
Yes.
I appreciate that. Then if we move to Mr. Bortes, and that's at the middle of the page, and the sentence starts, now, just in a nutshell. Do you see that?
Yeah.
Mr. Bortes says, now, just in a nutshell, do you know personally what gave rise to the shortfall? In other words, why were invoices paid not in respect of the amounts they were issued for, but why was only partial payment made? Mr. Baltic, I think that was an inquiry in the entire PRASA at all the contracts. I understand, Mr. Baltic. And there was many departments involved to look into this one. And finance were the general view of these contracts, excuse me, and I think that the payment have suffered and was not only these contracts, but majority of the contract that we had. It seems that I know that there were some delays in payment, Mr. Bortes. Will it be correct then to say, to Mr. Commissioner, that the short payments as reflected in the statement were not as a result of any defective, insufficient performance delivered by CIA? Mr. Baltic, correct? Will that be good? Very well. Mr. Commissioner, may I ask that you accept the statement as submitted for Benny? Again, do you accept that Mr. Baltic is testifying before the Commission that there were works CIA was not paid for, and it was, let me stop there, there were works that CIA wasn't paid for, correct?
Yes, it is here and it is in his report to the chairperson.
Do you also confirm that Mr. Baltic testifies that the CIA was not paid, not because it didn't perform, but because there were inquiries or delays within PRASA, correct?
Yes, to the extent that it's what is reflected here, I agree with you.
Thank you. And then I will just skip then to page 268, if you will. And the reason I do that, at least again on my reading, is because they get into the technicalities about what GSMR is. And I will start with Advocate Bortes, where he says, no, no, no. Do you see that? So it says, no, no, no. I appreciate the manner in which you explain this because it is extremely technical in nature, and for lay people like us, it is sometimes impossible to understand the nuts and bolts and the veracity of how the system actually works. Based on your evidence now, can the Commissioner accept that CIA was duly appointed to attend to this additional works, which forms the subject matter of this document, which appears at or in Exhibit C from page 397 up to 410? That is the entire document. That is correct. Yeah. And then were you personally involved in the execution of these additional works that are busy dealing with? Yes, I was. Again, and again, forgive me for the repetition. Do you accept that he's testifying that CIA was duly appointed to perform additional works and that he was involved?
Chair, I'm just trying to see, are we still dealing with the same company?
Yes, we're dealing with the same contract. Because we're going to move on then to CIA Quatron, I think is what you're anticipating.
Well, because I mean, I'm seeing that you are on the GSMR project.
Yes.
My understanding is that that was done by CIA Rail.
Yes.
At least in terms of the summons that we received.
Was done. Yes. Again, I will be guided by you.
No, that's why no, sorry. You are asking the questions about this.
Yes.
I thought maybe you know that we are still dealing with CIA consulting engineers.
No, for sure. If you say it's CIA Rail, my question is a limited one. At least I hope it comes across as that. My question is a limited one of saying, and I accept, again, that's why I'm accepting that you say it's CIA Rail. If it is CIA Rail, as you say, do you accept that CIA Rail performed the additional works? At least that's what Mr. Baltic says.
Chair, I think it's important for us to establish which company we're talking about. Because this is one of the strange things about this inquiry. You have one company in liquidation, it does a 417 inquiry. In the 417 inquiry, you're talking about the liability of other companies. Now, what is the relevance of that liability of the other companies in the Section 417 inquiry of this company? So that's why I'm saying I don't think we can just gloss over that point. And maybe I can demonstrate in the papers that CIR Rail is the one that was doing GSMR. The summonses are there. I mean, if you want, Chair, I mean, the easiest point, the easiest place to go to is the report of 21 November to see what company was doing what project.
We're not really interested in what the companies were up to. You are being asked what Mr. Baltic apparently replied to Mr. Botha at an insolvency inquiry. If you have knowledge about these matters, personal knowledge, other than what's written in here, you could share that, but what's written in here is what is written in here.
Yes, Chair.
Yeah.
We've skipped a couple of pages.
Yes.
So I don't know whether there's a company that gets spoken about in those pages, or in the inquiry, they're just pushing documents regardless of which company they belong to. So that's why for me, Chair, it is very important that when we're talking about this, because this is, as I said, a strange thing about this inquiry, that why are matters that relate, because I also saw, he was anticipating that I'm talking about CIR Quatron. I am seeing CIR Quatron here. Why are these matters here in this inquiry? I can accept, Chair, that this is what is written, but I just wanted clarity, and I think it's an important clarity, whether we are still talking about the company in liquidation, work that was done by the company in liquidation. And I thought maybe he knew, but I mean, if he does not know, we can move on.
Yes, thank you.
Do you accept that with regard to the GSM, do you accept that with regard to the GSMR project, which you say was performed by CIR Rail, Mr. Baltic is testifying that the work was performed by CIR? Yeah.
I don't see that.
Okay.
So, sorry, you are saying that in this transcript,
Yeah.
Baltic says PRASA appointed CIR Rail, but the work was performed by CIR Consulting Engineers.
No, that's not what I'm saying. I'm speaking to a particular project. You've
Yes,
testified.
GSMR. Sorry, I didn't mention the project. I'm saying, you are saying on the GSMR project, PRASA appointed CIR CIR Rail, and the work was done by CIR Consulting Engineers.
No. I'm taking your evidence of saying that CIR Rail was appointed for that project. Is that not your evidence?
Yes, it's in the record.
Yes.
Yes.
And what I'm then going forward with is that Mr. Baltic is testifying that the company that was appointed to perform additional works under the project performed those works. If you say that's a stretch, I'll accept it, but that's what I'm putting to you.
Yes. So what I noted about Baltic's report, Chair, is that he says CIR in general, and then there's an acronym he uses. I think it's SLS or something like that, or SLR, which I suspect he wants to say CIR Rail. So there's a confusion of the companies that are doing the project. But in terms of the papers that are submitted in court, the company that was appointed for the GSMR project is CIR Rail, and CIR Rail is the one that issued a summons for that project.
Thank you, Mr. Tingswai. In your report to the chairperson, parenthetically, did you ever point out these discrepancies in Mr. Baltek's report?
No, I didn't. You remember, all of us were supposed to submit on the 30th. I was not supposed to mark Baltek's report.
Yes.
He wrote his report, Kobue wrote his report, I wrote my report, Mukhashwa wrote his report. Same day, tight deadline, we all submitted.
And in your report, you refer to Mr. Baltek's report, correct?
Do I?
You-
About him not making concessions.
You do.
Can you take me there?
Go to volume 8.
Just a minute. Yes.
It's at page 259.
So is it at 259 where I speak about
Well,
Baltek's report?
your report is at 259, where you speak about Baltek. Let me get it for you. Is at 262,
Okay.
at paragraph 2.4.3.5.1.
Yeah, so many points. No, I'm not talking about Baltek's report. I'm talking about the pleadings.
Oh, okay.
Because Baltek, in the pleadings, they say Baltek is the one that concluded the additional work contract. So this is not about Baltek's report.
Yes.
His name is there, but it's not about his report.
So that the
Oh, sorry,
Yeah.
the next one is his report.
yes.
Or where I'm saying that his report is consistent with the pleadings. Yes.
So you had read Mr. Baltek's report when you filed yours.
Yes.
Did you correct his discrepancies that you are describing today about
No.
confusing the companies?
No.
Thank you. May I ask that we go back to the transcript then?
Yes.
That's at 1601, and we are at page 268. Why did you not highlight that Mr. Baltek was confusing companies to the chairperson?
It was not important.
You say that the pleadings were confused because there was reference and interchangeable.
No. I'm saying that Baltek used CIR, and if you look at his report, he also uses SLR.
Yes. I accept that. You don't have to prove it to me. Or
Yes.
what I'm asking you.
So what I'm saying is that CIR is CIR Consulting Engineers. So it could not be that the acronym he attributes to it is the one that he writes. So it seems like he was using the two interchangeably.
Is it not important when the chairperson asks about the CIR matters, and you say there are 6 summonses, to point out what the discrepancies are because you are reporting to the chairperson about those matters? Did you not consider that important?
No.
Did you not think that it would affect how the matters are considered and what the concessions, which you disagree with, of course, what the concessions are related to? Did you not think that would assist the chairperson?
No, sorry, I don't disagree with the concessions. I'm saying that I did not see major concessions.
Indeed.
So, but the discrepancies, I did not think it's necessary to report to the chairperson. The chairperson has an interim report, she says. Judge Makhubele has an interim report of CIR Consulting Engineers in liquidation. When we report to her on 4 matters. one of the matters is that of CIA Rail Solutions. So she knows that this matter has nothing to do with this interim report or the subject company of the interim report. She knows that, unless your instructions are that she didn't know.
No. My question is a different one. You've been asked to report on all the matters.
Yes.
And if there are points that cause confusion, do I understand you to be saying that, notwithstanding that there would be a possible confusion of which company, in respect of which contract the concessions were made, you didn't think it necessary to clarify that?
No, because the nub of the question is what has been pleaded? Why are we pursuing these matters? And that is the answer that is given to the chairperson in very clear terms, that this is what has been pleaded. And the other thing that I add is that, chairperson, judge, there is a suspicion of a fraudulent misrepresentation that was made by CIA Consulting Engineers. And we have requested further and better particulars because we suspect that there was a fraudulent So that's all I'm giving her. We're not going into the nitty-gritty. There's no time.
Thank you. Are we at 16 of 1?
Yes.
Yes. Again, I ask that the tribunal bears with me. I will recite the paragraphs I consider relevant. So we start at Advocate Bortes, just below the yes. It's at page 268, just below the middle of the page, below Mr. Baltek's yes, I was.
Yes, I see that.
Yes. Mr. Bortes says, and according to your personal knowledge, did CIA comply with all the obligations or responsibilities as provided for and contained in this document, which appears at page, or from page 397 up until page 410? And then referring to Quatron, Mr. Baltek says, CIA Quatron complied with the requirements of this, of our request. Then Mr. Bortes says, now based on your evidence, it seems that if one has regard to what is contained in this agreement, and more specifically on page 405, you will find a financial calculation or analysis. It says, quote, the estimated costs for the required approvals are as follows: the total needed budget for the scope extension of the technical advisor and supervision, the new digital railway signaling radio network project, is 21,626,138 rand and should be made available. Now, on that score, Mr. Baltek, can the commissioner accept that there was compliance from PRASA's point of view, that this budget was made available to the specific project? Mr. Baltek, the amount, this is what CIA Quatron has requested. I'm not sure if this is the amount. Mr. Bortes, yes. Yeah, but this is the amount that have been requested by CIA Quatron, and this amount, as appears at on page 405, was that also the amount which approved and accepted by PRASA? Mr. Baltek, PRASA has disputed the amount requested by CIA, and CIA Quatron has requested or asked to offer PRASA the rates according to the Engineering Council of South Africa. Mr. Bortes, yes, and upon request was those rates, as far as you know, then submitted or provided to PRASA? Mr. Baltek, I think yes. Mr. Bortes, yes, they have, confirms Mr. Baltek. Now, based on your evidence, do you know from a personal perspective, if you turn to page 405, Mr. Baltek says yes at page 269 now, if one has regard to the work which form part A, step 1 to 5, 12 million, whether that work, one, was executed successfully by PRASA, Mr. Baltic, Siaya Quatron, by PRASA, by Siaya Quatron, can the Commissioner accept that? Mr. Baltic, yes. Again, just to stop there, do you accept that the evidence that's been given here is that Mr. Baltic is confirming that work was done and that an invoice an invoice was submitted for those works to PRASA?
Yes, he's also confirming that there's no agreement on the rates.
On the rates, yes, that's correct.
Yes, he's saying that they requested. So it calls to question when CIA pleads an agreement in their particulars of claim, which one are they pleading? Because they requested this amount, it was not approved. And then they just went ahead and did the work. I'm not sure how Baltic wants to put his neck on the block for these numbers when they are not approved. There's no agreement.
Yes.
That's his evidence.
But do you confirm that he had testified that there was an agreement and that the work was performed?
Yes, I did say when I was going through his report that he's contradicting himself. He is saying there's an agreement and he says the rates are not agreed. So to me, that's an oxymoron. So there's no agreement. So if you look at the entirety of his evidence, it's that there's no agreement.
Well, can we put it as that you say there's no agreement, but he testifies that there is an agreement?
Yes, I'm saying what you've read very well says there's no agreement. And then he says they give him a number, 12 million of work was done, and he confirms it, that the work was done. I'm not sure why he's putting his neck on the block for the number, because there's no agreement on the number. So they're picking one item on the 26 million, whatever, 21 million, and then they say, of these numbers, this number was done. He says yes.
Yes. So again, limiting ourselves to Mr. Baltic's evidence, he testifies that the work was done because there was an agreement and CIA was not paid for it.
Well, I don't know if you can say, as far as this witness is concerned, there was an agreement, because he's just pointing out to you that this is how agreements were concluded. So when you say to him that what's his name? Baltic was agreeing that there was an agreement, I think from him he is saying no, because there was no written agreement. What Baltic is saying there is, yes, the work was done. 12 million amounts of work was done, and I don't think he can say anything more.
Chairperson, for your convenience, I wish to refer you back to where Baltic does say there is an agreement.
Yes, I know Baltic said there was an agreement, but as far as the witness is concerned, he didn't think there was an agreement.
Yes. The record will speak for itself. It will show that Baltic says that. But, Mr.
May I just raise something that it seems to be glossing over quickly? What is being put to Baltic by Mr. Bottas? He is reading from a document which we don't know what document it is, on page 405. He says the estimated costs for the required approvals are as follows. When you read that, he's saying from the mouth of Mr. Bottas himself, there's no agreement. It's estimated, it's for approval. There's no agreement.
We'll take that up with Mr. Bottas when he comes to testify. May I ask then that we go back to volume 8 and we're going to the report you submitted to the commissioner. I beg your pardon, to the chairperson. It starts at page 259.
You want to refer it to 259 or not?
No, that's where we should start. Thank you. And you confirm that you wrote this report and addressed it or sent it to Mr. Zide?
I have confirmed
Yes.
that, Chair.
Just as a matter of start, do you in this report ever mention CI or Mr. Mabunda's implication in any corruption at PRASA?
I don't think I do.
Why didn't you do so?
Because we are asked to comment about the matters and why we are pursuing them.
Did you not think it was? Oh, sorry.
The one thing that I point out, which is not in the pleadings, is our suspicion that, and I'm still talking about, I don't want to talk about things that are outside of the pleadings. I'm talking about our strategy, our suspicions that these agreements are tainted by a fraudulent misrepresentation.
Did you not consider it important to highlight that, like corruption with a service provider?
No, I thought it's important to highlight that these agreements are tainted, are suspected to be tainted by a fraudulent misrepresentation. That is not in the pleadings, but I thought that a person in the position of Judge Makhubele, who had been, who's a lawyer, once you say to her that this is our suspicion, on these contracts, not on many other things. Because if I thought, well, I didn't even consider that, but I thought that if you say to a lawyer, this may be tainted by fraudulent misrepresentation, a lawyer would sit up and think about the matter more carefully than maybe more than just thinking it's a rands and cents issue.
Did I hear you correctly? You said the fraudulent misrepresentation was not in the pleadings,
Yes,
but you thought that relevant to mention in the report.
yes.
But you didn't think it relevant or important to mention the corruption that you suspected around these companies.
Yes.
Thank you. And then, in relation to Mr. Baltic, you mentioned earlier that he was in trouble, and that's why he may have testified the way he did at the inquiry, correct?
I said that Mr. Baltic had concluded a contract with a service provider when he did not have the authority to do so. The service provider alleges that it has rendered the services and has rendered an invoice. Now, Mr. Baltic is sitting with an invoice and no contract. And he is supposed to process the invoice, and he can't because he doesn't have a contract and he doesn't have a budget for it. And that's the quagmire that he found himself in.
Do you raise your quagmire in this report to Mr. Zide?
No.
Why didn't you do that?
It's in the pleadings.
I thought you said the fraudulent misrepresentation was not in the pleadings. Did I misunderstand you?
I said, yes, you understood me, but it seems as if you don't understand the quagmire. The quagmire is in the pleadings. If you look at the pleading says this contract was concluded by the correct people. Later on, a variation was done by Mackenza Mabunda and one Soren Baltak. Now, that variation is not authorized. Baltac is not authorized. CIA comes back a couple of months later with an invoice and says, remember that thing that we spoke about, here's an invoice for it. And Baltac is in a quagmire. It's in the pleadings. We plead that Baltac was not authorized. We deny that the contract was concluded. We say, even if it was concluded, Baltac is not authorized.
Did you ever seek to challenge or set aside those agreements or variations that Baltic had concluded was not authorized?
There was nothing. You see here that they're reading a request for approval. How do you set aside a request for approval? That's why the allegation from them is that it's partly written, partly oral. Because the approval was Baltac's approval. So you can't set the document that we had as an organization, according to this, is a request for approval. That was not approved.
Do you accept that in general law or contract, you can conclude a contract partially oral, partially written?
Yes.
And as long as that contract exists, as I'm sure you know, under Odekral and all these principles of law, it is binding and enforceable until set aside.
No, so you don't move from general to public law.
Yes.
So when you're saying in general, if I conclude a contract with you, we can do it partly oral, partly written. But when you come to public law, it's a different kettle of fish.
Yes.
And I mean, if you are a Mackenzie Mabunda who's done a lot of work for PRASA for over many years, you know exactly who you can contract with and who you cannot contract with.
Indeed. And then just to go back to I'd say the nub of what we are here for, do you accept that from when Judge Makhubele arrived to the date of 30 November 2017, she was not sidelining you but engaging you on these matters?
If I accept that, I would have to think that Mokhashwa was lying to me when he said he was barred from speaking to us about these matters on the 15th of December. No, I don't accept that.
Do you remember my question?
Yes, you're asking me if I accept that the judge was not sidelining us.
Between October and November, you at the date of your report, was my question. I didn't refer to December.
Oh yes, for the 2 weeks. Yes, we worked with her. I mean, we dealt with these matters with her for 2 weeks. Yes.
Yes. May I ask that then we turn to volume 29, specifically page 71.
29.
Volume 29, that's correct.
Oh, sorry. Thank you. Yes, the Hawks.
Page 71. It's an email. Yes. Are you at page 71, Mr. Tingswai? 71.
7-1.
It's an email. Or email chain.
I think they may have given me the wrong volume 29.
Does yours not have a page 71?
No, it starts at 80. Maybe there's another one that was supplemented by these pages that I have here. 29. I have to try and fish it here.
Do you have a spare copy?
No, they don't have it.
I think we'll take the adjournment and the witnesses can start looking for the document. Have you got the document?
No, Chair. No, Chair, I don't have.
Well,
Oh, there's one that's handed to me now.
have you got the page now?
Yes.
Yes, then we will
Page,
continue.
it's written page 71.
Yes, thank you.
Yes. May I ask that
yeah,
you...
This email.
Sorry.
Yeah, I've seen this email, yes.
Thank you. In the sort of 2/4 of the way down is an email from the chairperson addressed to Mr. Zide. Do you see that?
Yes.
And the email says, please arrange a meeting for me with the internal auditors, LRC, today to finalize this matter. Do you know what the acronym LRC stands for?
I think she's saying legal risk and compliance.
Were you in the Legal Risk and Compliance Department?
Yes.
I suggest 1400 hours. I will also update you on the meeting I had with the council yesterday, as agreed with Mr. Makhubele last week. However, PRASA representatives did not attend. And then the email at the top from Mr. Zide to the chairperson, do you see that?
Yes.
A response on the same day says, Dear Chairperson, indeed the meeting will be arranged. I will check with LRC. They had advised that today they were to have a Christmas lunch as a department. Kind regards, LK. Did Mr. Zide arrange the meeting and invite you to it?
I'm not aware of this, of an invitation from Mr. Zide. I think, Chairperson, if my memory serves me well, Mr. Zide may have told us about this, but it was after the fact. Because our departments were next to each other, we always invited his department, the company secretariat. It was smaller when we had Christmas lunches. So he knew that we have a Christmas lunch. And I think he mentioned this maybe a day or maybe the next week that I had received this email from the chair and he asked for a meeting. I told him, he said, I told her that you guys are having a Christmas lunch.
Do you accept that as of 8 December 2017, this email on its face shows the chairperson was willing to engage with you at this stage?
Yes.
Thank you. On 15 December, you called Mr. Makhubele, correct?
Yes.
You asked for an update on the Siaya matters, correct?
Yes.
And he told you that he had been told not to engage with you on the matters further, correct?
Yes.
Thank you. Did you ever follow up or ask Mr. Zide why that was so?
No.
Did you ever seek to follow up with the chairperson about what Mr. Makhubele had told you?
No.
Why not?
There's a pecking order and I'm a little bit lower down. I can't just walk up to the chairperson and say, this is what I hear. But I mean, there was something that kind of disturbed me before the 15th, the call of the 15th, and I testified about it, that Mr. Makhubele came to meet with the chairperson by himself. He thought I was in that meeting, and I was not aware of that meeting. So by the time he says he's barred from speaking to me, I knew that there was maybe some preference that the chair wants to deal with these matters herself without our knowledge. So I mean, but it didn't come as a surprise to me when he said he has been told not to talk to us about these matters.
Do you accept that the previous boards, Popomelefe board, had done the same thing with regard to the Worksman's investigation and dealing directly with attorneys?
Yes.
Can I put it to you then that the reason you were not surprised is because a previous board had interacted directly with attorneys?
No. I was surprised because the difference between the two is that Worksmans was doing a thoroughgoing investigation, and everyone and their uncles were in investigation. So it was expected that unless and until you have been cleared, then you can start dealing with the lawyers, which is exactly what happened. That after some time, we started dealing with the investigations of Worksmans and the matters that they were dealing with. I mean, I'm certain that your senior would know that we instructed him on the first Yangena application. We, as executives, went to meet with him. That came from the Worksman's investigation. So I'm saying where it started, we were not involved, but over time, we then got roped in this, and it was their matter. So it is an investigation that they decided to start. They didn't come and take away matters that were ongoing and say, we are going to do them to the exclusion of the responsible managers.
But on the face of it, there's nothing clandestine or suspicious when a board engages directly with a firm of attorneys about matters of PRASA.
Yes, it depends on the context. Yeah, everything's about context. There are contexts where there's something that doesn't look right in the light, and there are contexts where it's normal.
But at this stage, do you accept that the chairperson was still soliciting or asking for reports and engaging you on this matter?
So, Chair, my evidence is, which I've said, the first inquiry from the chair was normal. But when it became too involved, it became less normal. And when we were then barred, it became very strange. And when settlements were concluded on these matters, yeah.
Yes. Did you not consider it necessary to put in writing as you were interacting with Mr. Zide? You mentioned, let me put it in context, that you were at the bottom of the food chain as far as you're concerned. But you'd been interacting with Mr. Zide, correct?
Yes.
Did you not consider it necessary when Mr. Mukhashwa told you that you were barred from interacting on these matters to address a memorandum to Mr. Zide at least?
Well, Chair, these matters were not as important to me as they were to the chairperson. I had a lot of other work, and I just got on with my other work. I mean, I really did not feel that they justified the time that was being spent. I mean, these reports that are asked at short notice, and I'm just saying that, Chair, I don't mean to be disrespectful. I'm just saying that because you start litigation in 2015, up to November 2017, you have not made traction. And it's not because of PRASA, it's because the plaintiff is stuck. So something like that, you know, in my list of priorities, I don't think it was in my list of priorities. What I was worried about is that one day we're going to hear that something has happened with these matters and we would not know, because I could see that that was where the trend was going. And that's why I made the call on the 15th of December. But this was not important to me.
Do I recall your evidence incorrectly when I say to you that yesterday you said because you knew the parties that were involved or the characters, you thought it important to stay close to it and be involved with Ms. Mukatedi?
No, you remember it very well.
When did it suddenly become unimportant?
No, I'm saying I was not about to spend an inordinate amount of time on this part of it. If the chairperson felt that she had the wherewithal to deal with these matters, I was not going to stop that from happening because of the other work. I said yesterday that we had to, one of the burning matters was the second review application that we launched against Siangena. That was very important. We had been given a bloody nose the first time, and we went back to court, and that took a lot of my time. I really was not going to ask Mr. Zide, can you please find out from the chair what's going on with that other matter. I didn't understand why she was spending so much time on this matter herself. So I was not going to ask questions that require her to spend more time on this matter. It was not an important matter. These are not important matters. The Dominus Litis party did not know what to do with these matters. So I don't understand why time was spent on this.
Chairperson, I'm going to move on to the settlement, which is a different topic, and I see that it's 11:15. Is it perhaps a good time to take the tea adjournment?
We can take the adjournment, but let's be mindful of time because I believe we would be adjourning for the day at around 1 o'clock today.
Or if I can make a suggestion, I think this topic will take me about 10 minutes if I just close that and then, so that we have the guillotine having fallen. Oh, okay.
I think we will take the adjournment.
Thank you, Chairperson.
Yes, thank you. We may continue.
Mr. Dingiswayo, you'll recall that we've gone through Mr. Baltek's report, and we've gone through his evidence before the inquiry. In the ordinary course of events, taking into account that you considered these matters unimportant, the CIA matters, it was responsible of a board or a chairperson of the board to seek to halt the incurring of legal expenses that would perhaps risk exceeding the amounts claimed. Do you have any comment on that?
Chair, the legal expenses pale in insignificance when it's a 60 million claim. There's no way that we can spend even half of that prosecuting these claims, especially with a plaintiff like this. I mean, I think if that was the concern, do you settle baseless claims of 60 million or spend 5 million you spend the 5 million and get your costs back? The legal costs, no. That would be, geez, the mess there is very bad.
I think I would have to refer you to the Worksman's report, but do you accept that the Worksman's, as at 2017, had been paid 132 million for the investigation?
That number sounds right.
Yes.
Yes.
So do you accept that a risk with regard to particular matters would arise that legal costs do exceed the claims?
Well, if you really
Yes.
if you really don't know the difference between the Worksman's investigation and these claims against CIA, you shouldn't opine and do the comparison if you don't know. But if you know, then you understand. I mean, the chair would have known, or maybe would have access to how much the budget of the legal department was for all matters. I think at the time, we would have been sitting at 75 million, not just for the CIA matters, for all the matters that we're busy with. That horse trading is very, very bad. To say you're settling 60 million because you want to save legal costs, very, very bad horse trading.
Okay. I ask that we then move on to the instructions for the settlement from Mr. Zide. Those are the written instructions, and they are at volume 8,
Yes.
and it's page 272.
Oh, the letter that was in the hand of Advocate Botes.
No. Oh, well. It is the letter that's in the record signed by Mr. Zide.
Yes, it was in the hands of Advocate Botes. I testified on that. Maybe you forgot.
So paragraph 1, if you're there, says, I confirm that you were instructed to defend the actions instituted of the Gauteng Division of the High Court under the case numbers indicated below.
I think it's here under.
Here under, yes. And before I get to the cases, you stated in your evidence yesterday that 6 matters were instituted.
Yes.
Do you accept that only 4 of those 6 were settled?
Yes.
Do you accept that 1 of them were not settled because they were still under investigation?
I don't know why they were not settled.
Okay. I suppose, let me refer you to the correspondence. With regard to CIR, DB Consulting Engineers, now in liquidation, 2.1 says, in respect of case number 74281 of 15, process instructions are that you pend both the file and the arbitration proceedings until you receive further instructions. You are instructed to confirm with the liquidators that the amount claims by CIR, according to the documents attached to the particulars, appears to arise from initial contract of 5.6, which appears to have been settled. The amount, the total amount for the project is indicated as 14. In this regard, the outstanding amount, if any, will be the difference between 14 and 5.6. Do you accept that this matter, there's no instruction to settle it, but to pend it?
Oh, yes. Yes, Chair, there's no instruction to settle. But it's an interesting thing that it just accepts that if the contract is 14 million and 5.6 was paid, then the difference is outstanding. It's very strange.
What was my question?
No, I've answered your question.
What was it?
Your question was, do I accept that that matter was not settled?
And your answer is?
I say yes.
Thank you.
And I note that there is a strange thing happening here, which says the contract is 14 million, you're paid 5.6, and we think the difference is outstanding. Because for every claim that you make, you have to prove that you've rendered the services to the satisfaction of the client. I mean, yeah, but I don't think it's key for this tribunal. I was just making an observation. I mean, I wouldn't have written that, even if I was trying to say, just go and check the numbers. But, yeah.
Paragraph 2.2. In respect of case number 77383-15, you have advised the chairperson that you did not file a plea because it was agreed between you and CIR's legal representatives that the amount claimed under this amount was paid in April 2016. Do you accept that there was no instruction to settle this claim?
Yes.
In respect of case 73934 of 15, the amount claimed is 7 million. PRASA's instructions is for settlement of this claim as per the amount. This is the first amount that Mr. Zide instructed Makhubele to settle, correct?
Yeah, to capitulate on.
Yes. In respect of 7933-15, slash.
73933.
73933/15, the amount claimed is 8 million. PRASA's instructions are to settle this amount. Do you accept that this is the second matter of the 6 that Mr. Makhubele was instructed to settle?
To capitulate on, yes.
There's no instruction to capitulate, at least insofar as this document is concerned. And again, putting aside what you think, I'm asking you about this document. Do you accept that the instruction is settlement of the matter?
Yes.
Thank you.
I think I've made my point.
In respect of, I beg your pardon, sorry.
I'm saying I think I've made my point. If you're claiming 15 million and you pay 15 million, you capitulate. But if you want us to use the language of the letter, it's fine.
And then 2.5, in respect of case number 47598 of 16, the amount claimed is 15 million. PRASA's instructions are to settle this matter. This is the third matter Mr. Makhubele was instructed to settle.
Yes.
And then in respect of case number 47597-16, the amount claimed is 21 million. However, after investigations and verifications by PRASA's instructions are that the amount is due and payable for settlement. This is the fourth.
Yes, and that's for CIR Rail Solutions. I think you skipped that, which was not in liquidation.
That's the one I'm reading, 2.6.
Yes, I think you skipped the heading. Remember when you started, you started with the heading.
Oh, yes.
And you
yes.
read CIA now in liquidation. I'm saying you skipped the heading there, which I think is important because that company is not in liquidation. But
Yes.
it was, yes, it comes in under the guise of there's an interim report in the inquiry of another company. So let's settle this one.
Indeed. Do you accept that 2.6 refers to a settlement of that matter?
Yes.
Thank you. And then moving on to, and for your convenience, reading the heading, interest payable, 2.7 says, it was noted that in some instances in the summons instituted, the interest claimed was to be reckoned from the date of invoice. The instruction to you is that the payment of interest should be reckoned from the date of summons. This is not capitulation. It is evidence of Mr. Zide having applied his mind and following the defenses that were set out in your report of 30 and Mr. Mokhashwe's report of 30 November. Do you accept that?
No, Chair, I think Council has been very generous to Zide. I don't see where he has looked at the report. I mean, this is, so if you go to court, you either get interest from the date of summons, which is the latest, or the date of your invoice. It is never a given that moral interest will be calculated from invoice. So that is never a given. So, I mean, it's probably like a few bobs that makes the difference here. But I think the statement that you make that this thing that is written here is because Zide has considered the report is not borne by what is written here.
Mokhashwe's report set out that one of the defenses was that the contract does not provide for interest being charged from the date of invoice. Is this instruction not in line with that defense?
Can you take me there?
Okay. Starts at page 233 on the same volume.
Which page?
I'm going to refer to you now. Sorry if you just bear with me. It's close 14. Just also look at the report of 30th. Okay. My senior is going to assist me with it, finding the clause. I will move on from it, but we'll come back for it. And then, where were we? Yes, at volume 8.
Page 273.
That's correct, yes.
Paragraph 2.8.
Thank you. And then we move on then to paragraph D at 274. It says, full and final offer. You are instructed to tender this offer as follows, or Yeah. 2.9.1, liquidators of CIA DB Consulting Engineers, now in liquidation, in the total amount of 30 million plus interest. Do you accept that this offer was made to the liquidators of CIRDP and not to CIRDP directly?
Yes, the instruction is to make.
Yes.
Yes.
And then the attorneys representing Sierra Rail Solutions in the total amount of 19 million plus interest. Then moving on to clause E, confidentiality clause. 2.10, as discussed with the chairperson, you are to include the confidentiality clause in the settlement offer. In your evidence, you take issue with the inclusion of the confidentiality clause. Why is that?
I take issue.
With the inclusion of the confidentiality clause. You, at least as far as I recalled it, you testified that this is what, or one of the factors that you considered rendered the agreement suspiciously secret.
Yes, I think if you this is something that it does not require confidentiality. So you've got claims that are made and they're in the public domain, and then you settle those claims and you say that must be kept confidential. It's a public entity. I think that you can't really do that unless you want to protect. If you wanted to protect some proprietary information of a third party, you probably could, but I don't think that you can. And I think also maybe you'll take me there. The wording of it was quite cumbersome. Yeah.
Okay, let's go there. And I think you're referring to the offers made under notice, are you?
Maybe. Let's go there.
Go to 282 of the same volume.
(282).
That's correct.
Of 8.
Of volume 8, yes. 282. Do you not have it?
Yeah, I have a different.
A different one. Do you have 284?
Yes.
Yes. You can use that. Is it before you?
Yes.
So if you go to the last take notice just before the signed ad Pretoria, it says, take further notice that the existence, nature, terms, and conditions of this agreement are strictly confidential and shall not be disclosed by either party in any manner or form, directly or indirectly, to any person or entity under any circumstances. Is this the suspicious clause you're referring to?
Yeah, it's quite tight.
The either party is PRASA and the CIRDP in this, correct?
Yes.
And saying that to disclose to any party other than means that PRASA is included and would include anyone at PRASA, correct?
No. Remember, these settlements are reached, and I may be wrong, but there are 3 people who are privy to these settlements. It's Judge Makhubele, Lindikaya Zide, and Kromet Mulepo. The executives who are responsible for these projects don't know. The people who were running the matter before Judge Makhubele came on board don't know about this. Now, the effect of that, and I mean, it's not by accident. It's not that they don't know because they are ignorant. They don't know because there was a specific. That's how these settlements were done, that other people don't know. And that's, so when you then include this in that context, I think that there's problems, because practically you are saying the people who would have known that this is done between the three have to come and tell the other people at PRASA. But they would have known that the process leading to this was limited to 3 people, the others were excluded. Why would they then include others after the fact?
The prohibition in this sentence is against either party, correct?
Yes, I agree with you.
So there's no prohibition against the people who are involved. It's the parties to the agreement, which is PRASA and CIRDP.
I agree with you.
Thank you.
But the people at PRASA who know of it know that other people at PRASA were excluded.
Look, I'm not going to argue with you about confidentiality clauses and agreements. Can we move then?
I'm not arguing about a confidentiality clause in an agreement. I'm bringing the context to a confidentiality clause in the agreement. I agree with you fully about the confidentiality clause in an agreement.
Yes. Just for completeness, President, I ask that the Commission or Tribunal have regard to volume 11A, just for your recorder. It's just a matter of reference, and it's the evidence of Mr. Mukhashwa at the Zondo Commission. Specifically, it is set out at page 181. So volume 11A, page 181, is the transcript of Mr. Mukhashwa's evidence, and he was asked whether or not he considered the inclusion of the confidentiality clause to render the agreements secret, and he said it is not unusual or completely unusual.
Yale Mukhashwa writes, so, and says, this is the settlement offer, and they receive a letter that says, that's not the settlement offer. So, this dance that you are seeing here is not a negotiation. The exchange between Matopo attorneys and Diale Mukhashwa is not a negotiation. Negotiations happened and an agreement was reached. After that agreement was reached, Mr. Zide was asked to write a letter in accordance with that agreement and call it instructions to Mukhashwa attorneys.
Just before you go, could you just complete it? Mr. Zide was asked by whom?
Chair, I don't know. I think the evidence here is that it was by the chairperson. There's an email, I think, that was shared with the commission. But from a personal knowledge point of view, I don't know. But what one gleans from the correspondence is that the negotiation and agreement precede the dispatch of the letter from Zide to Mukhashwa. Because when it lands and Mukhashwa tries to write something different, they say, that is not what you instructed. And they say, this is what you instructed. So I understand what you're saying. I mean, we can talk about what happens generally. We can talk about the rules of the court. If we take all of that and remove it from the facts of this case, we are going to be lost.
You say negotiations had taken place and completed. Between whom?
I don't know.
So-
Remember, these things are happening without our knowledge. You're just gleaning from correspondence. Unless maybe you have a different take to what I'm saying. That here's a letter, it goes out to Mukhashwa. Mukhashwa writes a different letter, takes it to Matopo. Matopo says, that's not your instructions. To my mind, and if you have a different proposition, I'm happy to hear it. To my mind, the negotiations have happened. An agreement has been reached. There's a dance between the lawyers to make it as if we are having a negotiation. But unfortunately, the people involved, maybe it was not properly scripted, this dance, because the people involved, the other party betrays the fact that the agreement has been reached. They betray their knowledge of what is supposed to be attorney and client information. And that's why when we got to that letter, I reminded you that this is the letter that Mr. Botes said he's going to get from his chambers. This is the other side's counsel. He went and got it and came back with it and showed it to me. First time I saw it on the 9th of March, 2018. So every time we analyze what's happening here, we must come back to, I think it was a slip. I mean, I don't think that letter from Matopo was a very, wise. I think that maybe a phone call would have been better, but they elected to actually record it. And I think the note is bolded. That those are not your client's instructions. Our poor lawyers were chided to say, what are you doing? You are scampering an agreement that has already been reached. And I think you're right. They do say your offer is not in terms of Rule 34. So, yeah. But that was a dance. That's my view. And maybe you have a different one.
You told me that negotiations have taken place.
Yes.
I asked you if you knew between whom. You've said you don't know,
Yes.
correct?
Yes.
And you don't have any evidence of that having happened, correct?
What do you mean? I just told you why I think that happened.
Yes, those are your thoughts. Do you have any evidence of your thoughts?
It's the letters. Why are the letters not evidence? I did not see people doing it, but I'm reading their correspondence, and their correspondence tells me something else.
So it's a suspicion and not evidence, correct?
It's not a suspicion. It's written down. There's a letter that goes and says, this is our offer. They say, that's not your client's instructions. How do they know that? Maybe they should have said, no, we're not accepting that offer. This is what we want. That would have been a better dance. But this was a little bit clumsy because they were very explicit, very clear. That's not what we were instructed, and that's it. So for me, that is evidence.
Thank you. Again, I must highlight, we are going to submit that you approached the transaction with suspicion. Yesterday you said it was important. Today you say it isn't. That is why you are fudging very elementary issues of settlements without prejudice or without admitting liability, and fudging or pretending to be confused by elementary issues such as having confidential clauses in agreements. Do you have a comment?
Yeah, I was hoping that you'll give me a different proposition of what the letters show, but that's fine if you want to stick to that. So you have to understand my evidence correctly. I did not think that anyone at PRASA needed to spend time on the CIR matters. I watched with glee as I saw CIR stuck in its own mud with badly drafted papers that can't come out of better. So I did not think anybody at PRASA need, until we get maybe better discovery and further particulars, then maybe we must act. But the chairperson, Judge Makhubele, thought this is very important. So when you're saying, I did not think it's important, that's the context within which I'm talking, and that's the context within which I spoke. So that is my evidence, that not what you are saying.
If I may then refer you to 6 of 1. We're going back to the Auditor General. 16, I beg your pardon, I keep making this mistake. Thank you, Mr. Maleka. 16 of 1. We're going back to the Auditor General's report.
Oh, sorry, I think it's this one. Right in front of me. Almost beat me. Yes, almost beat me.
If everyone's there, I ask that we all turn to page 450. That's 450.
Yes, I'm at 450, Chair.
The heading, underlined and emboldened, is irregular expenditure. Do you see that?
Yes?
And number 3 says procurement and contract manager dash worksman's open bracket corp COF7 close brackets. Do you see that?
Sorry, where's that?
That's the
On the same
shaded
page.
shaded area. Yes, number
Oh,
3.
yes. I see that.
And then there's a reference to the Public Audit Act and Section 217 of the Constitution. And then we scroll down to 451,
Yes.
referring to the award of
Sorry, we're not scrolling. We old school.
Oh, no. Sorry. I apologize. And then 451 says the details of the award are as follows. Again, shaded is service provider. Do you see that?
Yes.
Below that is worksman's attorneys. Do you see that?
Yes.
Again, next column, shaded, amount paid to date as per SAP report, 130 million. Do you see that?
Yes.
And then if you go down to 452, under the heading auditor's conclusion.
Oh, 452.
Yes.
We're not going down. We tend to this.
I apologize.
Sorry, you're saying auditor's conclusion.
Indeed.
Yes.
And then the second unnumbered paragraph, starting with therefore. Therefore, the above results in the non-compliance with Section 217 and Section 51(1) of the Public Finance Management Act and the payment made to the service provider, which we remember is Worksman's, result in irregular expenditure. Did the chairperson raise this issue of the Worksman's report with you?
Yes, I think the first meeting, she raised. I think we discussed the Worksman's investigation, but not this. I don't think we discussed the finding, if I remember well.
So the CIR matters were not the only matters of concern to her, correct?
I'm certain that they were not the only matters that were of concern to her.
Indeed. In fact, if we go to, and I apologize for this, volume 6. No, it's 6. I'm going to the transcript of the board meeting.
What is 6? Yes.
And if we could go to
6
page
is here.
806, that's at the bottom of the page.
806.
Indeed. It starts just under Ms. Skeepers.
Yes.
It's chairperson, okay, but let's finalize the agenda. I was still saying the purpose of the meeting, we all know that there's an email memorandum. What we are here for is to discuss the 3 reports, public protector, the AG, worksmen's attorneys, and then we have invited, she goes down, just under Ms. Skeepers again, Makhubele Handel. Do you agree that that's supposed to be Makhubele attorneys?
Yeah, Makhubele Huntley.
Huntley,
Yes.
yes, which was Adiek at the time. Because they do not, they do the public protector's report, we've also, with regard to the worksman report, invited Kena and worksman's attorneys. So once again, do you accept that the chairperson has taken an interest in the public protector's report and the worksman's report?
Yes.
And she has invited the attorneys involved in the implementation of those reports. Do you accept that?
Yeah, maybe let's not personalize it, because it's the board that, it looks like this is an invitation from the board. I'm not sure why you are personalizing it. The invitation, it says we have invited.
Yes.
I take the we to be the board.
Yes.
Yeah, you were saying she invited them.
Does she not lead the board?
She is, she does, yes.
Okay, for completing or closing this point, may we then go back, I beg your pardon, to 16 of 1. At page 158.
158.
Yes.
Yes, I am at 158.
That is an email from the chairperson, Makhubele, 158 to 159. Do you accept that?
Yeah, my copy is very illegible. I can't see the normal email header.
Yes.
On my copy.
Can I assist you by saying go to 161? You will see that it is signed as from TAN Makhubele.
Oh, yes.
Yes. This is an email that raises issues that she considers or necessary to discuss at the meeting. Do you accept
Okay.
that?
It looks like it.
Do you accept then that when she raises the agenda, it is items that she had thought were important to be discussed at the meeting, correct?
Sorry, can just give me a second? So on page 158, Chair, it says after, because I think this is where this email starts. It says, "Dear Mr. Makhubele, the PRASA BOC has resolved in its meeting held at Cape Town on, I don't know what, November 2017 to convene a special urgent meeting as follows." Then the next paragraph, she says, the purpose is to consider and make decisions on recommendations made in various investigative reports conducted by various entities into allegations of maladministration. So it seems to me that this entire thing flows from that meeting of the board. So when the chairperson writes to the then company secretary and says, invite Makhubele Huntley, she's not saying that as the chairperson of the board. She has consulted, she has had a meeting with her colleagues in the board, and they have decided to deal with these matters.
And she raised them and itemized them in an email from her.
Yes, but in that email, she says, we discussed with the board, on whatever date in November, and this is what we want to do as the board.
So you accept that at the first meeting, she did raise the worksman's issue?
At the?
First meeting on 9 November.
Yes.
Thank you. I'm going to move on from that. I'm not going to engage about the interpretation of the email.
No, but it's just there.
Yes, no, certainly.
That's what it says. She says that this is what the board wants to discuss. Not this is what I want to be placed on the agenda.
Once again, those are issues you can engage yourself in. I'm not going to have a back and forth with you. Can we go back then to 16 of 1? And we're going now to page 458. The shaded number 6 is due process was not followed in the appointment of the service providers - legal panel. Do you see that?
Yes.
PRASA at the time, under yours and Matangoya's management, was using an illegal panel, correct?
Yes.
And any expenditure you incurred using that panel was irregular expenditure, correct?
Yes.
And the expenditure that you incurred was in the amount of, and that's set out at 459, 132 million. That's correct.
Yes, the department, the expenditure that the department cumulatively over those years, from 2011, I think this is a very good, Chair, maybe if I may be allowed to just go back to the point I was making earlier about the budget of the legal department, from which we're paying for the CIR matters, comparing that with Worksman's. So you'd have seen that in Worksman's, as at 2017, 100 million. The PRASA legal budget from 2011 to 17 is 132. So that's why I was saying that comparison I'm sorry to go back to that point, but I think this page makes that point very clear.
But you accept that the Auditor General found that you were using an unlawful panel and you spent 132 million between 2011 and 2017?
Yes. May I just explain, Chair? I joined PRASA in 2013. After joining PRASA, I asked for contracts that we had with the lawyers on the panel. And after a couple of requests that were not met, I thought this is untenable. So I asked SCM to procure a panel for us in 2014. That process didn't go anywhere. So, I mean, it's very interesting. You find people coming at a certain time saying and wanting to accuse us around this issue, when the first people to note it were us. But I think we need to also say, because of the failed attempts by the SCM department to get us a panel, this is what caused the irregular expenditure in the amount that is reflected there. It was not because we were sitting and enjoying using this panel. We wanted this to be done. We wanted to be done properly. But because we were frustrated, we were left with no option but to use this panel. And the reason why the Auditor General believed that it was, you will see that the irregularity starts in 2011, is because according to the Auditor General's audit, the absence of evidence is the evidence of absence. So when they asked for evidence that when the panel was first set up, PRASA went out on tender, they couldn't find that evidence. So because that evidence was not there, they found that from 2011, then there was an absence of the, so yes.
2013 is between 2017 and 2011, correct?
Sorry?
2013, when you started, is a year that is between 2011 and 2017.
Let me check. Yeah.
And so between 2013, or from 2013 to 2017, you were part of using a lawful panel.
I've answered that question.
Thank you. Let's go to 261.
Where?
And under the heading,
Which bundle?
we're still at 1601.
261.
461, sorry. It's late.
461.
Yes, under the heading auditor's conclusion.
Okay, yes.
And I'll read it for you. It says, management comment is noted. This panel was compiled by SARCC and no SCM process was followed by PRASA in the setup of the panel. Furthermore, there is no SCM supply chain management policy followed when
Sorry, where are you reading?
under the
46.
auditor's conclusion.
Oh, 461, yes.
461.
Sure.
And I'm at further, there is no SCM policy followed when selecting suppliers from this panel. It is done based on the preference of the user and not on the rational basis to ensure.
Rotational.
Or rotational, I beg your pardon. Rotational basis to ensure fair, equitable distribution of work, and there are no technical proposals submitted every time services are required. Therefore, the method used to select the service providers is not fair, equitable, transparent, competitive, and cost-effective, and does not comply with the requirements of Section 51(1)(a), Roman 3 of the PFMA. Further, the SCM policy prescribed that the database, which is viewed as the legal panel, is valid for the period of 3 years, and as no supply chain management process was conducted in the last 3 years for the setup of the panel, this is further non-compliance. The irregular expenditure has been disclosed in the annual financial statements. The finding will remain on the management report. I'm going to take this in parts. Do you accept that the finding here is that even when you're procuring from this panel, you don't do it on a cost-effective, fair and equitable basis?
Chair, this is, in my view, completely irrelevant to this inquiry, but let's engage it. The first engagement we had, the AG came to us and said, asked us, how do you procure services? We said, well, we look at our panel, and if there's an attorney we know, there's two things we do. It's either we know you have experience in something. So when the PP report, which was referred to earlier, Public Protector's report, arrives, we look at our panel, and from our knowledge, Makhubele Huntley has dealt with Public Protector issues before. Then we give them a call and we say, we've got a matter, can you assist? And in other instances, one of the divisions deals with rentals, so there's a lot of evictions. So in other instances, you don't find anyone in the panel who has done evictions. You approach one of the panelists, you say to them, can you assist me with an eviction? They start building capacity in that area. And when you have an eviction matter, you don't take it to the next person because you'll save time here. You've built capacity, So you take it there. So we try as much as possible to make sure that we, as it were, spread the love. But, so we had this, we explained this to the AG, and we said to they said, no, but that's wrong. You need to do RFQs. And I said to them, I have asked about this. And what the market is telling me is very concerning. That if you do RFQs, you are engaged in a race to the bottom. So you have an eviction matter. You send an RFQ to a couple of people. They come back. The one says, I'll charge you so much money. And according to the rules, you take the cheapest. But is that the person who's going to give you a quality service? You don't know. And I found out from my own inquiries that people actually do that. I found out that even big firms, they say we're going to charge you less because they realize that the other firms say they'll charge less and they get the job. And they know that once they have the job, they're in. It doesn't matter how long it takes and how much you're going to spend. Then there's a second problem. The second problem is that now you have a matter, your quote is 10,000, you've worked and now you are at 9,400. The matter is not done. And you can see that you're going to need more time on the matter. What you have to do in terms of the treasury regulations is that you have to go to National Treasury. You have to estimate. If you're going to breach the 10,000 by 10%, you ask for approval internally. If you're going to breach it by more than 10%, you have to go to National Treasury. Now, I have a live matter that's running, and I'm receiving pleadings, but I have to go and ask for an extension from National Treasury. How long is that going to take? What does that do to? So we explained the practical difficulties of this way that was proposed by the AG. And we asked humbly for them to give us advice. We even said to them, you have a legal department. Tell us how they do this. Because what we are hearing in the market is that the RFQ mode has a perverse incentive and has also problems where you are not going to be able to comply with the treasury regulations because now you breach your quoted amount, now you have to go in somewhere else. And if you spend more, you are irregular. And they never came back. Because they didn't have answers for us, they went to SCM. And they had the similar discussion with SCM. And SCM was happy with what they were saying because the SCM department had always been wanting to see what's going on there. I think they thought there's kickbacks, nice kickbacks that we are getting, or something like that, and maybe they wanted to cap that. But they had an interest in this, and I didn't understand where the interest came from. This is why on page 460, when you talk about the actions that will be taken in that box, there's compilation of whatever, and then who's going to do that is the senior manager of SCM, and they're going to do that by the first quarter of 2017. So I'm saying, Chair, we were in a bit of a difficult position where we had a panel which I had understood. I mean, myself and Martha didn't know how this panel was constituted. But we were told that the rates that the lawyers charge us is what they put in their tender that allowed them to be on the panel. So whatever it is that they charge us is something that they tendered for. Now, I must say, and council is right to, this finding is right to point out the two things. I got concerned when I didn't get the contracts, and I wanted that corrected. But the issue around the distribution of work, I think is a difficult one. I mean, I'm in private practice now, and I've taken a decision not to work for public entities, simply because I refuse to enter the race to the bottom. I mean, I could probably easily get work by quoting lower rates and knowing that once I'm in the matter, it will run, even if I've reached my quote, because my client can't fire me. The irregularity that they spend, it will be for their account. So it's Chair, and I'm saying it's absolutely irrelevant for this hearing. But that is the difficult position that we found ourselves in.
I'll address the relevance later, but you've mentioned kickbacks, and that it is based, that if AGSA finds that you don't use on a rotational basis, it is based on preference. It would be unreasonable and completely unfair to suggest that you received kickbacks when there's no evidence of such. Correct?
I'm lost.
It would be unreasonable.
No, I said SCM was interested in this whole thing of briefing. I said maybe because they thought we were getting kickbacks.
And I'm saying to you,
yes,
because there's no evidence of that, that is unreasonable, insensible, and completely unfair.
But you're saying it as if they said that.
No, I'm saying to you now,
Yes.
if we were to infer from
Yes.
this AGSA's finding that you kept the panel, and let me put it in context. I'm going to go to the board suspending the panel, and I'm going to suggest to you that your resistance was not because you were receiving kickbacks, and that to say you kept using this panel and had attorneys that you preferred within this panel doesn't justify any inference, any suggestion that you received kickbacks, unless there's evidence of that. It would really be unfair on you, correct?
Yes, yes.
Thank you. And again, I've already explained to you why it's relevant. It's because, and I'm going to refer the panel to volume 8, specifically the resolution. Yeah. Actually, I think I went to the wrong thing here. Sorry, let me just
What page?
I beg your pardon, I think just bear with me. Sorry, I apologize. It's at 16 of 4, page 298.
16 of 4.
Page 298.
Yo, I've never seen that. 298.
Yes. And the reason I refer to this is that one of the charges, or at least one of the items in the terms of reference, and I read, again, I'm sure the tribunal has that, is that Judge Makhubele terminated or caused to be terminated the mandate of PRASA's attorneys and personally appointed another firm in their stead to represent PRASA. And that, I put to you, is also set out or supported by this resolution. Specifically, I ask that you refer to item 4.
On 299.
Yes. Okay. Yeah. The terms of reference are in volume 14, President, at page 1033.
I don't need to go there.
Yes. The relevant section is paragraph 5.2. It says, whether the respondent's conduct as chairperson of PRASA was incompatible with the office of a judge, in that all of these cases that PRASA was involved in, she pays special attention only to those of CIA. Next, that she marginalized the PRASA's legal unit and terminated or caused to be terminated the mandate of PRASA's attorneys and personally appointed another firm of attorneys in their stead to represent PRASA. That she negotiated with CIA's attorneys and entered into a confidential settlement that is manifestly and materially prejudicial to the interest of PRASA, relying on non-existent major concessions on its liability to CIA allegedly made by PRASA employees at the insolvency inquiry, and frustrated PRASA's attempts to resist enforcement of the settlement, thereby rendering herself guilty of gross misconduct as envisaged in section 177 of the Constitution. Were you aware that that was one of the charges or terms of reference?
No, I don't think I've seen the terms of reference.
Yes.
I don't recall seeing them.
So let me highlight three of which are relevant, or at least insofar as your evidence is concerned. It is the special attention to CIA, which you've addressed. It is the termination of the legal unit and marginalization, termination of the panel of attorneys and marginalization of you as a legal unit, conclusion of the agreement, and engaging of the attorneys, which in this case are Makhashwa. In respect of those, am I correct that you've accepted that engaging attorneys as a board is not irregular or unheard of at PRASA? The board engaging attorneys?
No, so we're conflating two things that we shouldn't.
Yes.
Yes, so that's a general statement. It's not what you read in the charges.
Which part of it?
So remember, my evidence is that there's a point where it was normal, then it moved to being less than normal, and then it moved to being absolutely bizarre, and culminated in what I thought was doing, serving the interests of CIA, of the CIA companies.
Yes, and that is something that the
So
panel...
that's not normal.
Sorry.
So that the whole thing is to get. So if you want to take one part, yes, I agree. But if you take the entirety of my evidence is that in the end, the chairperson worked hard for CIA and against the interest of PRASA.
Indeed, and that's something that
those
the
matters.
tribunal will have to assess.
Yes.
But just to confirm your answer, at least because I didn't get it, you confirm that there's nothing clandestine on an ordinary basis for a PRASA board to engage a firm of attorneys directly.
Yes, I've said that.
Thank you. And with regard to the relevance of the suspension of the legal panel, you sort of implied that it wasn't. It is, because that's one of the issues that arise here. Just to point that out to you.
No, you're going in blocks. So
Yes.
I thought you were coming to the legal panel issue.
Yes, it says terminated and caused to be terminated the mandate of process attorneys personally appointed by her instead of, that's the relevant issue, the termination of attorneys.
Yes.
And the reason I've referred you to the resolution of 1 December is that that is itemized at number 4. Do you accept that?
Yes.
And that's the direction of the board.
Yes.
Do you accept that it's a...
Well, I don't know, hey? Because there was something that saved us from this. If your instructions are that this was a resolution of the board, then those are your instructions. But we were told that this was the resolution of the board. And in December, Lindikaya Zide deposed to an affidavit that says that this is not a resolution of the board.
But when you received the resolution and
Yes.
before you read Mr. Zide's affidavit, this was, as you understood it, a resolution of the board.
Yes.
And the fact that the resolution says the panel must be suspended, according to your evidence earlier, and it comes from the board, cannot be attributed to Judge Makhubele. It is a decision that was taken by the board.
Yes.
Thank you.
Are you going to say which she led, like you said?
Yeah, which she led, indeed. Thank you.
Great.
But it was a decision of the board.
Okay.
Thank you. And then it was a legitimate concern in the light of the AGSA's findings of irregular expenditure, correct?
Yes, it was a legitimate concern.
In fact, when you used Bowman Gilfillan, which trades as Bowman's, Bowman's is not on your list of panel, the illegal panel. Is that correct?
It is, on the old panel.
Okay, I'm going to have to refer you to where the panel is set out. That is at 16 of 1 at page 218. 218.
16 of 1 is this one. Yes.
And again, I may have missed it, so I ask that you go through the list, which the heading is Annexure A, legal panel list as provided by the legal department, which is your department. So if you just go through that list and point to us where Bowman's or Bowman Gilfillan is.
No, sorry, I'll accept if it's not there, but
Yeah.
we have briefed Bowman's a lot. They've done a lot of our labor matters.
Indeed.
And this is from what I'm seeing, this is an unsigned document by the then internal auditor, I think, of PRASA. So I don't know what to make of it. I don't know where he got, I see it says, as provided by the legal department, but...
Yes. And that's your department. And the fact that you continue to use Bowman's despite them not being on the panel, I don't think
no,
helps
you are misunderstanding me. I'm
Yes,
saying
you
that
seem to be boastful about it.
I had understood that Bowman's is on our panel, and I had used it a couple of times on a number of mainly labor matters before, and I think it was the first time I used them on something that was not labor.
Again, Sorry.
Yeah.
Again, Mr. Tingiswayo, the fact that you used a law firm that is not listed here, which makes your conduct irregular, cannot support an inference without any evidence that you received kickbacks from Bowman's, correct? It would be unfair on you to make that inference.
Well, I don't know who's making the inference that you receive kickbacks.
It's posed in the hypothetical, President.
It's posed?
It says it would be, not that it is. No one is making the inference. I'm saying
Well,
such a person.
Let's just deal with what evidence we do have, not with hypotheticals. Otherwise, we'll be here next week and the week after that.
The evidence before you, which is the list I've referred to you, is that Bowman's is not on the panel. And what I'm speaking to with this is where I started was we are going to make submissions, that an inference of corruption, an inference of fraud is not justified when there's no evidence on it. You can't infer corruption from irregularity. We will submit that that is what is happening here, and the reason it is unfair is because even in instances when people like Mr. Tingiswayo, as employees of PRASA, acted in a manner that would be deemed non-compliant with the law or irregular, we can't infer that they received kickbacks despite, because there is no evidence before you. That's the relevance of it.
If there is no evidence, then there is no evidence.
Indeed.
Yes.
Again, going forward with what I'm saying, Mr. Tingiswayo, the fact that you acted irregularly according to the policies of PRASA and the section 217 would not justify anyone applying to the LPC or to the High Court to have you struck off. It doesn't make you unfit, it doesn't make you not proper to practice as an attorney.
Yes, I told you the difficult position that we were in.
Indeed.
Yes.
It would also not justify anyone laying a complaint before the LPC claiming that because you acted irregularly, you are corrupt, claiming that because you acted irregularly, you received kickbacks.
Yes.
Thank
Yes,
you.
without more, they can't do that.
Thank you.
Yes.
Can we then go to volume 29, I beg your pardon.
We've not touched 29 before. 29.
29.
Is this the loose list?
The loose one, yes.
Okay. Which one?
We're going to
Hawks.
start at 80, we're referring to Hawks.
The
yes.
Hawks.
Yes. You've been waiting for this one.
Great. No, I thought you were referring to it earlier when you referred to this volume, but it was a different page.
The background to this is that this refers to or is about cases relating to alleged fraud, theft, corruption, and contravention of the PFMA during the award of tenders at PRASA to Sufambu and Siyabonga Technologies.
Siyangena.
It says Siyabonga here, but again, I'll defer to you. I'm guided by the document.
Does it say Siyabonga?
Page 80.
Wow.
And then it says several
Says
witnesses.
a lot. It says a lot about this investigation. Let's continue.
Several witnesses, both PRASA and outside PRASA, have been interviewed. Statements were obtained. And then I'm going to refer to requests that were made to you. Again, your evidence yesterday in chief was that these were big matters which were serious. In fact, this is the reason you considered the CIA matters unimportant, correct?
Well, I mentioned the Mandamus application, Chair, that had been launched by the board that was led by Mr. Molife to ask the court to direct the Hawks and the NPA to do their work efficiently, because I mean, the basis of that application was that we're not seeing any traction in the investigation, and yeah, that was the concern.
Your eagerness gave me comfort that you'd answer my question. That wasn't my question. My question was.
So you.
Can I finish, please?
No, I understood your question.
Let me finish. Let me finish.
Well, let him say what he wants to say.
President, I was speaking. I was interrupted.
Well, he was then still speaking and he went on. I want him to finish what he started.
Thank you. Go ahead.
So counsel was conflating the criminal investigation, which is what this deals with the Mandamus application. So my answer was to say what I was referring to in my evidence is the Mandamus, not the criminal investigation. The criminal investigation is in the hands of the Hawks. The Mandamus is in the hands of PRASA. And that is what I thought a board would want to see to its conclusion, because that is important to ensuring the finalization of this.
Yes, you may now put your question.
Thank you, President. Page 92. I'm sorry, it wasn't a question, just a reference. I'm going to ask the question now.
I was ready to answer,
It's a letter addressed to you, and it appears to have been dated 12 October 2017. Do you see that?
Yes.
And the first paragraph, unnumbered, says, telephonic conversations between yourself and the section head of Serious Economic Offences Unit, Brigadier R.M. Makinyane, on 2007, October 3rd, and email from Colonel S.P. Makhubele, dated 2007, September 4th, bears reference. This is a follow-up from the telephonic conversation. You were to call me on Thursday, 27 October 5th, to indicate your availability, the availability of the witness supposed to give outstanding statements on our investigation. Do you recall the conversations?
No.
Have you?
So Chair, I don't recall receiving this letter. I saw this letter in my recollection for the first time because one of the things I testified about at the Commission of Inquiry into State Capture was the fact that the Hawks were just dragging their feet in this investigation, and the fact that one of the investigators had told me that they were being frustrated as the investigators by their seniors. So the first time I saw it was when the head of the DPCI responded to my affidavit in the commission.
Well, let's just look at what you said. You said you didn't receive this letter.
Yes.
Now, it says received on the 12th of October 2017, and there's a signature underneath that. Do you see that?
It's Lebogang Matsimela.
Who's that?
That was Mr. Zida's PA.
And when was the first time you saw this letter?
In around middle of 2020.
Yes.
After, I'd left Prasa at the time.
Do you know Brigadier Makinyan?
Yes, very well.
Had you had conversations with him about your witness statement?
About?
Your witness statement in
My
this matter?
witness statement.
Yes.
What witness statement?
About these matters?
I'm not a witness in these matters.
Okay. May I ask then that you go to page 81?
Yes, I'm at 81.
The heading is delays in this investigation. Do you see that?
Yes.
And then if we turn over at page 83, it refers specifically to Sufambu documents. Do you see that?
Yes.
And then at page 84, you asked what witness statements, and it says in the middle, the paragraph there, starting with the following. It says the following.
Sorry, I just wanted to check the context. We are at 84?
Yes.
Yes. Where are we at?
It is with regard to your question of what witness statements. It says the following witnesses have already been interviewed by the investigating team, and their statements could not be finalized due to outstanding documents which form part of this list. So this letter is about the delays in the investigations, and it says that there are witnesses who have provided statements with regard to the Sufambu matter.
Yes.
From PASA.
Yes.
And then it lists who has provided statements. That is Brian Alexandra, Ernst Swanepoel, Kevin Monsami, Stephen Ngobeni. And just below that it says, Mr. Tingiswayo was approached on several occasions on this matter with no success up to this stage. Copy of letter from section head, Serious Economic Offences Unit, dated 12 October 2017, that was hand-delivered, is herewith attached. Mr. Tingiswayo and Ms. Ngoye are potential witnesses on the matter, and they were informed on the 14th of August 2017. They have not availed themselves to finalize their statements. This is the statement I'm talking about. And that you weren't providing the statement and were the reason for the delay. Do you accept that?
That's what the letter says. But I'm not a witness to anything.
The Hawks considered you a witness. They wanted a statement from you.
Yes.
You didn't provide that statement, correct?
I've never been approached to provide a statement to the Hawks.
The letter is inaccurate on your
Yes.
contention.
But it's understandable, Chair. This is another one. The questions. Okay.
Sorry, you say you've never been approached.
I've never been approached.
So this is then an error somehow.
Chair, this is a unit of the police that has the power and the mandate to investigate corruption.
Yes, I know that.
And has not done so. We gave them volumes and volumes of paper. I went to the Hawks offices at one time and gave them. So when you look at this list that I was referred to, and the reason I was looking for the context and I got lost when council went to page 84, is because at the bottom of 81, they're saying they have copies, but they are looking for originals.
I see.
And all that entire list, they're looking for originals. How they have detail, if you look at it, the first, on 82, the first document they're looking for, PRASA tender procedures and procurement pertaining to whatever during period that to that. That's a very specific document. They got this from the copies. So what they're asking for are originals.
Yes, I understand all that. But were you approached on several occasions on this matter with no success up to
No,
this stage?
No, Chair.
That's all I want to know. Thank you.
President, it is 1 o'clock, and I propose that we adjourn, and if anything, we'll take it up on Monday.
Yes, I was hoping that we would have finished by now, but it is 1 o'clock, as you correctly pointed out. Yes. You'd have to come back, unfortunately, on Monday. We will start at 10 o'clock again on Monday.
With unfortunately as the operative word, Chair.
Yes, I was hoping we would have been done by today, but we haven't, with your evidence at the least. Nevertheless, you are warned to be back here on Monday. Well,
Sorry,
then,
Chair.
then that's it, unless there's anything else. Yes.
Sorry, Chair, just apologies from our side. I won't be here on Monday, and Mr. Prinsloo won't be here next week. We're just apologizing.
Yes, thank you. That will be noted. Is there anything you wish to say, Ms. Zungu?
No, Chairperson.
Well, then, that being it, anything you wish to say? No.
Thank you, Chairperson.
Nothing. We then stand adjourned until Monday, which I believe is the 15th or the 14th. Let me just check. Monday being the 15th of May, I believe it is. Thank you. We then stand adjourned.